with that. With that share up now. So I'm gonna get these slides back up and I'm gonna turn it over to them. And again, I'll be watching the chat as they speak. So if you guys have comments and questions, I will see if they're ready for those and I can answer some things off the cuff as they're speaking as well. So I'm going to turn it over with great gratitude to Dave and Morgan and let them take it from here.
Sounds good. And hello, everyone. Can you hear me?
We can now.
All right. All right. It's amazing when I can get on something like this without technical support. So welcome, everyone. A lot of names I recognize. Hello. And I'm going to turn it over to Morgan, and she's going to start this off. Questions are invited.
Absolutely. So for those who are not familiar with Dorsey and Whitney, we have a particular specialty practice with cooperatives. And so Dave and I work really regularly with cooperatives, particularly natural food co-ops around the country. We are both based in Minneapolis, but we work with co-ops in every state, as well as we have other attorneys who are in Seattle and Denver, as well as Salt Lake, with cooperative expertise as well. So today we're going to be talking about some particular considerations if your annual member meeting is coming up and you're either looking to postpone it or to hold it remotely. So the first thing we're going to sort of walk through with you here is what legal review you need to do to determine if you can do that. There are a number of different sources that are going to be relevant to this decision and determination, and we'll walk through them basically in the order that they would control. But the questions that you're going to be looking for answers to in those sources are going to be the same, and that's is there an express allowance or alternatively a prohibition on remote meetings? If you have some votes that you need to hold, can you do so by mail or via other electronic means? That can help really expedite a meeting and simplify the process of holding a remote meeting. And the last consideration, I think this is probably a little more unusual, but you should confirm that it does not apply to you, is do your controlling documents and state statutes specify that your meeting must be held at a particular time of the year, particularly if that time is right now. So we're going to walk through the sources that you're going to look through to answer these questions. The first place that you should start is the statute that you are organized under. For a lot of you, that's probably a co-op statute, but there are some states that just don't have good co-op statutes, or for other reasons, you might be organized as a nonprofit or a corporation. That doesn't really matter, but whatever type of entity you are, and that state statute should be your starting place. There, you're going to look for a provision in that statute that allows for remote meetings. One of the common formulations that we see in state statutes is they say remote meetings are allowed if they are expressly authorized in your bylaws. And if that's the case, you'll then have to turn to your bylaws to see if you've taken that step to authorize them. Your state statute might also delineate certain requirements that need to happen in order to hold a remote meeting. A lot of the common ones that we see are some formulation of everybody at the meeting needs to be able to hear each other and to speak by whatever means of communication you're using. So a Zoom meeting obviously would make that happen, as would a teleconference line or the like. But if there are specific requirements, you'll want to make sure that you comply with those requirements. A lot of co-op statutes are not as well developed as some of the corporate statutes. Some of your statutes are going to recognize that, and they will have a provision that expressly states, to the extent something is not addressed in this statute, but it is set forth in our corporate statute, that will govern you as well. If that's the case with your statute, you should go through that corporate statute as well to see if they address remote meetings and requirements. that corporate statute is helpful for you even if it isn't expressly binding on you, because it will give you a sense of what your uh, state regulators think is appropriate means for remote meetings. And so to the extent that you can comply with it, you should, since it's basically your state has decided this is relevant for a lot of organizations, it's probably a good guide for you as well. So after
Morgan, if I could interrupt for
yeah.
just a moment there, you are not, natural foods co-ops are not the only ones trying to figure out what you do about an annual meeting in this environment. And I've followed the electric co-ops. They have a blog or some kind of a listserv. And it sounds like a lot of states also have statutes that allow for remote communication in meetings that could be looked at as sort of overriding an old law, like a co-op law that doesn't say you can't do a telephone or video meeting.
That's helpful. Yeah, and that's one of the things is that the co-op statutes aren't really updated and revisited as often as some of the other statutes. And so it might not be that the regulators are saying you co-ops aren't allowed to have a remote meeting. They just might not have addressed the statute anytime recently to update it for changing times. So after you've looked at the statutes, your next place to turn is going to be your articles of incorporation or your certificate of incorporation. They're called different things in different states. It's unlikely that this organizational document is going to address remote meetings. They tend to be very brief and short form and basically just say, we are a co-op, here is our purpose, here is our authorized stock, and that's about it that's in there. But it's always good to double check because your articles of incorporation are generally going to control in advance of your bylaws. So after you've ruled out that, your next place to turn is your bylaws. If your bylaws have a provision regarding remote meetings, that's great. A lot of times those provisions are drafted to say that you can hold remote or electronic meetings if it's authorized by the board. If that is your formulation, then the one step that you have to make sure you do is have a board resolution or written consent that either generally authorizes remote meetings or authorizes it for this particular annual meeting. Your bylaws might also have a provision that states that in emergency situations, the board has discretion to either amend the bylaws or adopt certain policies to be in place just for that emergency situation. This one's a little more rare. We don't see it all the time, but every now and then it gets thrown in there. And if that's the case, great. I think this totally qualifies as an emergency situation, and that'll give you the authority to authorize a remote meeting here. The next place that you should check is if you have governance policies that govern how the board operates. And some of your bylaws might specifically state that the board has the power to adopt policies to address any matters that aren't specifically identified in the bylaws. If that's the circumstance, you might already have a policy that allows for remote meetings, or this is the perfect time to adopt that policy if you have the authority to put one in place now. The final place we'd suggest that you check if you've come up short on all of your organizational documents and the statutes is regulations that are coming out of the states day to day as we speak to address COVID-19. So these are like state emergency regulations, and often sometimes the governor's orders are including provisions that expressly authorize remote meetings, even if the statute or your organizational documents do not allow it. So that's a good place to check. You might see that these seem to be targeted to public companies, so SEC traded companies. But really, co-ops are incredibly analogous to that, in that you're really the only other form of legal entity that is holding in-person, large gathering annual meetings. So if they've addressed it for public companies, it's pretty safe to say you can rely on that for your smaller annual meeting as well. But if none of those situations have applied to you and answered your question, there's still some contract theories that we think can help you, and Dave will walk through those now on the next slide.
All right, thanks, Morgan. Anyone have a question at this point?
Anyone throw any questions in the chat? Please go ahead and do that. Or anyone want to say, hey, I'd like to ask a question. All right. Or so far they're quietly absorbing. So let's keep
I do
them
see
up.
one right
there
there.
is a question.
Can you call, Can you call your
Jenny
Secretary of State office? Yes, you can. The helpfulness of the Secretary of State office varies from state to state. The other thing that we are finding out as things progress right now is Secretary of State's offices are shutting down more and more. So at this point, they're doing bare minimum with filings. I haven't heard anything about how their phone lines are working, or if they're answering those questions that come in by phone the way they might normally, so that you may or may not be successful there.
Kat also brought up, if nothing else, nothing in bylaws addresses the possibility of remote meetings, is it therefore not allowed?
That's what Dave's going to talk about.
That's a very good question, and I was
Great
actually going to start off with that. Yes.
Excellent.
Good segue. Who was that who asked the question?
That's Kat Wolfram from Electric City Food Co-op.
Ah, very nice. So let me start off with, so it's actually fairly unusual in my experience that you have state laws or articles that say, or bylaws that say you have to hold the meeting by a certain date. It's not unheard of, but that's pretty unusual. It's a lot less unusual for bylaws to just assume that you're going to have a face-to-face meeting and not address at all telephone meetings or any kind of remote access. If you have nothing in your bylaws that prevents it, I think you almost always can say the board has authority to do what they think is right. And many bylaws, not all, but many bylaws make it very clear that the board has authority to make all decisions for the co-op that are not specifically reserved to members, and that is a fairly limited laundry list. Electing directors, approving a merger, approving a dissolution, there's not a lot of things that require a member vote. So boards really have a lot more, often have a lot more authority than people realize. So that's a starting point. But if you have something that in your bylaws that are, or in the state statutes or whatever, that is very clearly says you cannot, you have to have your annual meeting on a certain date or in a certain month, or it says you have to have it done, you know, within a certain time period after the end of the year, or it says meetings have to be done in person at a location, then you've got a conflict between reality and what the bylaws and articles say. Well, in my view, there's a pretty darn good argument that bylaws and articles are, that you can nevertheless do what you have to do. Part of it is pure practical, but there's also a legal theory that supports this. So if you have articles that say the annual meeting has to be done by April 30th every year in a, you know, community hall, you just can't do that this year. And I think there's a pretty clear theory that it's okay for a board to respond to the situation that you have and hold the meeting at a time when it's safe or in a method that is safe, remote or wait. I see Purple Carrot's question coming up. This is a contract theory, and I think this is pretty clear that the bylaws and articles of an entity, a corporation or a co-op, constitute a contract between the entity and the members or the owners. And there's a lot of common law about contracts that basically say if you're obligated to do something in a contract and it's absolutely impossible to do it because maybe it's illegal or circumstances don't allow it to happen at all, that you're excused from having to perform that contract. And force majeure is another theory that usually is limited to short-term events like flooding and that sort of thing, but we could be in a force majeure. In fact, if you read legal blogs, one of the common topics is what is your remedy if you can't perform a contract, and what does force majeure mean and how does it get applied? So I think there's a very solid practical legal position to say we'd like to comply with what our bylaws say, but we just can't. I mentioned earlier that I've been looking at the listserv from the rural electric co-ops. There's I think around 900 of them in the country. Most of them are pretty small, most very territorial. Most of them are rural or suburban, not really any in urban areas. And there was a dialogue going on about this on that listserv, and one of the lawyers, I think this gentleman was from North Carolina, made the comment, well, sometimes you just have to do what you have to do, and you have to ask for forgiveness. And I think that's a valid, practical way to look at it too. The risk of, and in applying these legal theories, I'm quite comfortable with them. It maybe is a little different situation if you have a lot of internal dissidence and drama in your co-op. And if you have someone ready to, go to the press or go to a meeting and yell about anything that you do that isn't perfectly clearly permitted, then it's a little harder to make this decision.
We've got a question, if it's okay, Dave, from Jenny at Dorchester Food Co-op. She said, that's kind of I think what she was getting to is, who would be the objecting party to postponing or remote? Would it be the state? Would it be our members? Like, where do you think the concern would be?
Well, I can assure you that the states are not going to be policing natural foods co-ops meeting habits right now. If you had a meeting and everyone got together, they might, but not if you don't have one. So it's going to be another member. Almost certainly another member. And I suppose the likelihood of members making a political challenge or criticizing, that's easy for them to do. The likelihood of members taking legal action on that seems to be pretty low to me. It costs a lot of money to take legal action. It's not simple. If you have any kind of if you get a letter that says, your meeting was invalid and because it wasn't done properly and therefore all the actions taken at the meeting are invalid, maybe a letter from a lawyer or a member, you can run right back with these kinds of theories. Hey, this is a contract, this is an impossible situation, we did this according to legal standards. And that probably ends it, or at least keeps it out of court.
And on our next slide, we'll cover some tips and suggestions that you can keep in mind to
mitigate this risk.
To mitigate that risk and hopefully not offend any of your members in making this decision.
But you're not regulated. If you were like public companies, they're regulated by the SEC, federal, and they have state regulators too, and they're pretty hands-off regulators. But the SEC came out with guidance right away about this. How do you deal with remote meetings and having to cancel and postpone meetings and all these things? And it was almost all of the guidance was aimed at be practical, give your shareholders as much opportunity to participate in an easy way. Make sure that you set it up so that everyone can participate, or as many as possible can participate. And so it's more on the method of holding the meeting than it is about the legal aspects.
Well, do you guys feel like we have a moment for another question here before we go to the next slide? Okay, great.
Absolutely. We have a lot of time.
I'm gonna pause for a moment. I know one or two of you are here only by phone, so I'm gonna do a little count to 10 in my head and say, if you're on phone and you have a question, go ahead and unmute now and speak up. Okay, I just want to make sure I paused for you phone only folks. Okay, so Kim, I believe from Suncoast Market, Kim said, if our bylaws require that an annual meeting be held at a place convenient to owners, can you write a policy that just defines place as online?
I think that's absolutely within the board's power. And if you want to really be careful about it, you could look at your bylaws and make sure that it gives the board a lot of broad power to run the affairs, and have the board adopt a policy saying we define places, including, at least in emergency situations, a remote meeting. And I think that would be a good roadblock in case anyone complains.
Great. All right. Any other questions before we move forward?
Well, I do. Do you agree, Morgan?
No, I totally agree with that. You could get into some very specific legal arguments and look at all the different definitions of place to support that, but I think it's a reasonable policy to make, and it can be well supported in a variety of ways.
Great. We got one more question I'm going to throw. Kat, I'm going to come back around to your question because it's kind of about peer examples. I think we'll get to those at the end and see if peers have anything they can share. But Adam Schwartz just asked, what is your view on co-ops just canceling their annual meeting? Just not doing it.
So I would say that if you indefinitely postpone it, that would be a better way to approach it. Because there is an obligation, almost every statute has an obligation to have an annual meeting of members, right? Canceling it entirely is maybe more than you need to do to deal with the situation that we're in right now, but there's a lot of uncertainty too. So I would say postpone it indefinitely. It's like all the weddings, very practical. People are saying, or the funerals, a funeral is going to be, we'll notify you about the funeral at a later date. And I think that's really clean way to deal with it. And if it lasts until next year and you just end up not having an annual meeting this year, well, that's just the way it goes. That's how I view that.
Great. I think we'll pause on the other comments and questions. I think they'd fit better maybe toward the end. And are you guys ready to go to the next slide?
Yeah.
All right. Is it going to agree to play? Didn't do anything when I told it to go to the next slide. Oh, back. There we go.
So these are just some really practical tips and suggestions if you are deciding to hold a remote meeting for the first time, and particularly if you are doing that without really express clear authorization from your statute or bylaws. So the first one Dave covered, make sure that however you set this up is in a way that accommodates the most people possible. One thing is just to be really aware of who your member base is and what issues you might be need to accommodate here. And so that might be making sure there's ways for people to participate if they don't have a computer with a camera or they don't have regular internet access. One thing we've come across actually with other co-ops who are already hosting online meetings is consider if you have any members who are hard of hearing or are deaf, and ways that they can still participate and make the meeting accessible to them. This is important not just for this consideration of the remote meeting, but it's also a potential Americans with Disabilities Act issue. So there might not be a way for you to accomplish it particularly on like this emergency timeline where you're trying to figure out new means quickly. But if you know someone is out there, have that conversation with them of how can we help you? How can we make this easier for you to participate, and do what you can there. Our next tip here is to just make sure that when you're sending out the notice of the meeting, you include a really good explanation of either if you're postponing the meeting, why you're postponing, or if you're holding it remotely, why that is important. Member communications and strong communications and open lines of communications is always important, but it's specifically important when you're making a new decision or taking this action. They haven't been a part of your board debates of why you're doing it this way. And so make sure that they understand. And that's going to minimize anybody coming and complaining about it because they have the full picture of why this decision was made. Our other suggestion, and this is, I mean, it's applicable to everybody, but it's specifically tailored if you know that your co-op has some internal drama or there have been some really heated issues lately that is divisive amongst your membership. If that's the case with your co-op, be sure that you are limiting the agenda for this meeting to only those items that really need to be addressed at this meeting, whether it's items that are required by state statutes, such as you have to elect your directors annually, or if it's item measures that need to be passed to keep your co-op functioning and keep things happening. But this isn't the time to push through a controversial agenda item. It isn't the time to really try and play tricks, let's just say that. So the goal here is basically avoid giving somebody the argument that you were forcing a decision through that would not have passed under normal circumstances. And of course, this isn't normal circumstances, and there might be some things that you have to address this meeting that you wouldn't address in any other meeting, such as things specifically related to measures you need to adopt to deal with the pandemic. And that's fine, but just think very carefully, more than you normally would, about what you're putting up for a vote in your meeting this year.
And Morgan, I would add, I think that's a very good point, that one way of dealing with the issues is to not have measures that are going to be really important for the future. Not that everything isn't important at an annual meeting, on the calendar or on the agenda, because you don't want to create an opportunity for someone who doesn't like it to challenge it. And if you can wait, that's a really good idea. It really mitigates the risk of having a remote meeting or no meeting or a late meeting.
And it goes back to the question of who's going to complain about this. If this is just your run-of-the-mill annual meeting where you elect a new slate of directors and adopt a couple of really run-of-the-mill policies, then even if somebody is upset, they're going to have a hard time making an argument that they've been hurt by the meeting being held remotely versus in person. So keep that lens in mind when you're considering your agenda for your annual meeting. And this is a semi-related point, is that you're now taking all of these steps to review your statutes and review your bylaws and your policies, and you've probably found some things you want to change, or you've decided, hey, we should probably fix this so that we're not stuck in this jam again if something else happens down the line, and give ourselves a little bit more flexibility. Save those amendments for next year. Make your list, write them down, get everything teed up to propose amendments at your next annual meeting, but hold it for now.
Yeah, let me just add a thought on that. If, let's say you decide, well, it's unclear whether we can hold the meeting in May instead of April, so let's hold the meeting in May and amend the bylaws to say that it can be held at any time. Well, I don't know if that would be a real good idea, because it would give people some basis for challenging. Well, that's not valid. it's almost like an admission that you don't have a right to hold the meeting late.
And that's everything that I had. I don't know, Dave, if you had any other final points before we open up to more questions.
I would just like to go back. I was talking about this bylaws are a contract theory, and I feel like that's a very strong theory, and I think it's the right theory about how you interpret bylaws and articles. But there is some old antiquated law that says, but at least implies that the bylaws and articles are not a contract. Or let me put it this way, it's very clear in a lot of states that it is. Delaware is the big, corporate law center. In New York, very clear, articles and bylaws are a contract, and you can waive a right, or you can, apply contract principles to them, practical principles. But there's a lot of states that don't have rulings like that. So it's not 100% without risk to take the position, hey, we're not going to follow the bylaws because it's impossible. But I think it's a pretty darn low risk.
All right. Well, time to open up the floor to more comments and questions for folks. Kat from Electric City did say, what about voting for new directors online? Is there any issues with that? I thought I'd throw that your direction.
Yeah, so there you're gonna want to go to your bylaws and statutes again, and you might have some specific provisions that are addressing whether or not voting in specific can be done by mail or electronic means, and you'll want to check what the requirements for that is. I would say if you have any votes that need to happen at your meeting and you can do it in advance by mail or electronic, it's probably going to be a whole lot easier than trying to hold a vote via a conference call or a video call. So you should certainly look into that.
I also think, I'll just add to that, a lot of the statutes and bylaws that this is focused on startups, so you're not going to have this problem as much as someone that's been around for 40 or 50 years. But a lot of the statutes have not been brought up to date with current technology. And so they create some questions about whether you can do online voting or whether you can do mail ballots. And that creates an issue if you have an old statute or bylaws that implies that. But again, I think you have to look at things in some kind of a practical way too. It's like the gentleman from North Carolina that said, sometimes you just have to ask for forgiveness. Well, if you've got a governor's order that says you can't have a meeting, and you have bylaws that say you have to have a meeting, it's pretty easy to figure out what to do.
True.
And another thing Morgan mentioned to me this morning is I think there's been some states that in their governor's orders that are, mandating that you don't get together, that might be used that might override state laws, at least for a temporary basis. So another basis for saying, or trying to figure out whether you have an issue here with a meeting.
We've got a couple more great questions here. If I can toss them your guys' way. Adam Schwartz brought up, how can we ensure that members have the right to vote and can vote securely if a live vote does need to happen at a meeting?
So, Adam, I guess you can't talk.
You absolutely can unmute and talk if you'd like to, Adam.
Okay, I will unmute and talk. Yeah,
so it's not 100% clear to me. So, could phrase that question again.
Yeah, so let's say, we go through and we try and do everything that we can vote on in advance, we do. So we do our board elections, and if there was a bylaw amendment that was scheduled, and we do that voting, electronically or by mail. But if a member, who has the right to bring up a motion from the floor brings up a motion from the floor, which, you know, and demands that there be a live vote at that meeting, how can we ensure that that vote could happen? And given the potential that, you know, some of these meetings might have hundreds or or thousands of people, you know.
Very good question. Well, one thing that you should do is make sure that no what actions that require a member approval are brought up with at an annual meeting, whatever the form of it is, without having it be on the agenda, because that's you don't want to have, that's just not, it's not consistent with the principle of members voting on something in an informed manner. It's not consistent with the principle of, you know, a board being the having the responsibility to decide what's important and then bringing it to the membership when it's something they have to bring to the membership. So that's how I would say. I think you could even make an argument that that's a motion like that is out of order, and you might address it. You know, I realize if you have people on the phone or if it's on a webinar or whatever, you don't want to snub somebody, but I think you could address it by saying it's not appropriate to bring up a matter for a member vote that requires notice, and because we haven't given it a notice, so let's take that as a recommendation for the board to study it.
Thanks. And I think going forward, that makes a lot of sense, but I think we might have some co-ops that are still, that haven't had that rule in effect beforehand. So I just was thinking about the worst case scenario about how we might protect ourselves from that. And I know that like Survey Ballot Systems, which is a company that folks use, has a tool called Direct Vote, which may allow for that for registered members of the at the annual meeting to vote. It's not proven that it can go to scale with 1,000 people or something like that. So I appreciate going forward. I think that would be certainly something I'd recommend. But if we are in the situation where a member does bring up something from the floor and has the ability to do so, there's a way to deal with that.
Yeah, I would look into any sort of manners for electronic votings that are targeted at public companies. I'm sure there is a solution out there. Whether or not it's at a reasonable price point is another question. But that's the simplest thing that I can think of, because you have the added difficulty of not just allowing a lot of people to vote at once in the moment, but also making sure that only people who are verified members are voting, and only people are only voting once as they're allowed. So there's a lot of complications there. When you're in the hundreds, that's difficult. You can't do a roll call. You can't really have everybody vote by chat and then tally it up. I mean, you could, but you obviously wouldn't have immediate results there. So you might have to get creative, but there also just might be some unique software solutions out there already.
Yeah, and let me just add a legal argument on that. There is, if in order to, let's say the motion is, let's increase the size of the board from 9 to 13, or reduce it from 9 to 7. Well, that's something that can't be done by the members without a process being done, which means including notification of it before the meeting and maybe a board approval first, maybe not. And I think you can rephrase it in the form, and I think that's pretty clear, you know, under basic governance and principles that apply to any co-op, even though the co-op is supposed to be, you know, democratically controlled. It doesn't mean it's a free-for-all. So I think you're on pretty good ground saying, hey, that's out of order. something
And
like
that's
that.
another thing that you can include in your communication with the notice versus this being really upfront with your members. Just say, these are extraordinary circumstances. We know that we've had this method of doing motions from the floor. We're not eliminating that going forward. We'll consider whether that still makes sense going forward. But for this time and this circumstance in particular, we have no reasonable means to take a vote on those measures. So please raise them in advance so that we can provide adequate notice to everybody and allow voting ahead of time.
I think that's really great. I want to real quick, because there was another comment on this issue. So just for those of you on the call who don't know, some of our stars might not know, Adam Schwartz, who was talking earlier, brought up this question, is with Columinate. Leslie Watson, also with Columinate, has added, she says, some food co-ops do have the practice of motions from the floor, even if it's not actually provided for in the bylaws. And basically what you just said, Morgan, is there a way for the board to make it clear that for this virtual meeting, it's just not permitted for good reasons? And it sounds like you're saying yes.
Yeah, I think so. I think that goes in with your clear communications is that if there are things that need to operate a little differently in order to make things happen in an online meeting, lay out ahead of time how you plan things to go. Lay out ahead of time anything that might be your standard way of practice that just isn't going to be feasible this time.
Okay. We did have.
I agree, and believe me, I'm not trying to suggest you shouldn't allow members to ask questions at an annual meeting.
I'm going to jump back to another question. Jenny from Dorchester did ask something you were, I think, talking about earlier, Dave. If the bylaws articles are not a contract, like you're saying, you're making an argument they probably are. If they're not, then why is postponing actually more of a risk? Or I think she felt she heard it was more of a risk if the bylaw articles are not actually considered a contract. Did you have anything to say about that, or did she understand you correctly?
So here's what I'd say. Let's say your bylaws or your articles say that you have to hold the annual meeting within the first 6 months of the year. And that's just not going to be practical this year. If the bylaws are a contract, the concept that it's impossible allows you to not comply with that contract. And it's just a very practical legal principle. If the bylaws, if you were going to challenge it anyway, you would say the bylaws are not a contract, and the obligation to have an annual meeting is in a statute, and you can't apply these concepts of impossibility and force majeure to a statutory obligation. So does that answer the question? It's a very fine legal point.
It's not that you're more at risk in that circumstance. It's just that you don't have these contract principles to fall back on.
Right. That's right.
To rely on to make a waiver and possibility argument. So you can certainly do that, but you just don't have that same background of case law in your court.
I'm gonna we're gonna have 12 minutes left. I'm gonna actually put Leslie Watson from Columinate on I'm gonna put her on the hot seat for a second since she's joined us. For those of you who don't know her, and many of you probably do from Up and Coming, our national conference, she was there this year, did some presentations. She is an expert in food co-op governance support. And I did want to ask Leslie, do you know, I know you have another question and I'll let you do that too, but do you know first, do you know of any examples of food co-ops having policies around online meetings and this sort of thing? Are there examples out there that startups might be able to pull from established co-ops?
No, not for online virtual meetings. Not yet.
There will be.
Yeah, right. Yeah.
Okay, cool. And then go ahead if you had a secondary question there.
Oh, I just was just augmenting the answer, or just really asking. I mean, isn't the real risk that absent the defense of the contract provision, that the measure itself would be deemed invalid? So, like, it would say, "Oh, the directors aren't validly elected."
Yes,
blah blah blah. That's like the yeah.
I think that's exactly right, Leslie. And although, you know, I don't know, when you get into what is a remedy, that's not real clear either. You know, and when you get into court, there's a lot of ambiguity. And I think if you got into court, you know, on the grounds that the director election was invalid, you would ask for remedies that are less severe than calling the director election invalid, like maybe, oh, then hold it right the next time or do another interim election or something like that. But frankly, it's possible, but highly unlikely that you're going to end up litigating this in court.
And
if
it's
you do,
again going back to you're not going to have this come up unless an action is taken that is objectionable on some other level. So that's a good thing to keep in mind in the coming year, not only to consider what you did on that in the agenda for that annual meeting, but just make sure you're really following all of your formalities and the steps that the board of directors take in the coming years. Make sure everybody is educated and aware of what their responsibilities are. Because if you're following all of that and you're following your statutory and bylaw requirements on all the actions that are taken in the coming year, then it's going to be really hard for somebody to argue that the board's actions were invalidated by this remote meeting.
Okay. I'm going to ask if we can take a quick minute, so we're getting toward the top of the hour, and see if I can really make sure for the startups that I'm kind of grasped and we've summarized the main advice that we're really hearing from you all. And what I think I'm hearing, Morgan, is first, start with reviewing your articles of incorporation, your bylaws, looking through all that for clues of where we're going, and that would be step one, and what's possible for you. Does that sound accurate?
Yes.
Okay. And then once they've done that, clarify anything they need to clarify, but the board makes some kind of clear decision about how to proceed. And then the next really big important point is to make sure you communicate proactively and clearly about the decision and why it was made. Would that be the next big step?
Yes.
All right. And then from there, deciding how to proceed, if there is going to be a meeting, making sure that you're clear up front what can and can't happen at the meeting, and do everything you can to make it accessible to people with disabilities as well.
Correct.
All right. Did I miss any of your guys' key advice for our startups today?
I would say you've covered it.
This has been incredibly clear and concise and just phenomenal. I really appreciate this. Jenny, did you bring up the Dorchester? It's also people without computers. It can be an equity issue. Absolutely, especially when you're serving a low-income community. So that's something your board will have to also think through. It's not so much a legal issue, but an equity issue. Absolutely.
Yeah. So if you hold a meeting that you have to have a computer in order to participate in, and you don't offer a phone option or something else, that's not a good way to do it.
So I'm going to point out, because it's not tasteful for them to do, but I'm going to point out, if you do this review and you still have questions, that you can reach out to Dorsey and Whitney. I know Morgan Helme and Dave Swanson would be happy to work with you, work with many startup food co-ops. So there's a lot you can wade through on your own from the suggestions they're making here today, but please don't be afraid to reach out to them as well and work with them a little to make sure that the solutions you're coming to are as legally correct as possible for your co-op. If they wanted to approach you guys to do that, I'm thinking in my mind it would be really good if they had kind of already looked at their statutes and their bylaws and had kind of cut and pasted, and kind of knew what you might need to look at, especially if they're not from a state you usually work in. Any advice to them, like if they want to reach out to you on the right time to do that, and what kind of things they might want to have in order to get your input on how they're going to go forward?
Well, I'll give this advice. Don't wait until after the annual meeting. I would say send an email. Just send an email and we'll figure out some way of getting you some guidance.
Excellent. Okay. Well, I'm going to take this moment to say thank you so much. This has been terrific, Morgan and Dave. We are so grateful to you guys. We've got I think we've got a couple established food co-ops on the phone too, because so many people have had this question. And we're getting lots of thank yous. I hope you'll look at the chat. Today's recording and slides will be made available via Google folder. And if you registered for this call, those will be emailed to you automatically within the next 24 hours. And wanted to make sure everyone knows that upcoming in the series, Thursday, we have Raising Capital in Rough Times with Bonnie Hudspeth of Neighboring Food Co-op Association. We're going to be talking about owner loan programs, the history of doing owner loan programs in very difficult economic times. And on Friday, we're going to be talking, we do a peer presentation from Assabet Village Co-op Market on pivoting your organizing, the pause and assess work they've already done on how should we proceed, what do we need to pause, how do we start serving the community without getting derailed from actually developing our business. And they've done some great work, and they're going to share with us about that. And then we've just had announced the last second here, on Monday, we'll have another peer presentation, Smart Outreach with Prairie Food Co-op. Jerry Nash of Prairie Food Co-op has been their outreach coordinator for a good long time, and he's come up with some really good thoughts about how do we be relevant and serve our communities during this COVID-19 situation, at the same time not create more work that drains our capacity when we as individuals and as leaders of our startups are also under strain. And they've come up with a couple of examples that have been very successful for them that they would like to share with you. So again, if you want to reach out to Dave and Morgan, email, you said, is the best way?
I would say, yeah.
All right, so when I send out the email to you all, I'll make sure I've got Dave and Morgan's email on there. So it'll be the link to the video and the slides, as well as their direct emails in case you need to reach out to them. And of course, you can always reach out to us at info@fci.coop to set up a one-on-one conversation about questions about your startup's organizing that you're going through. Those calls are free. We're happy to set a time to meet with you directly. And I think that's it for today. Really terrific, concise information and advice. Thank you so much, Morgan and Dave and everybody.
Thank you, and I'd like to thank Morgan and also one of our younger lawyers, Bree Whiting, who I don't know if she's on the phone or not, but she helped a lot with the background for this.
Thank you so much, Bree. We appreciate that background work.
Thanks a lot, everyone. Have a good afternoon.
Have a good afternoon, everyone.
You too. Thank you.
Bye,
Peace. Bye now.